Welcome to today's presentation, Smoke Signals, Understanding the Cannabis Industry and Insurance Market. Today's presentation is brought to you by the South Central Chapter of AICP and sponsored by AAIS. The purpose of today's presentation is to add dimension and perspective to what you may already know about cannabis and outline the basic terms, facts, and issues that matter most to insurance and compliance professionals tasked with understanding this relatively new and strange space. We will be talking about insurance issues, of course, but we will also cover a few non-insurance concepts that I believe are essential to understanding how the industry works and predicting how it will continue to grow. A few housekeeping matters before we begin. There will be poll questions throughout. We strongly ask you to answer those to your best of your knowledge. We definitely appreciate your feedback in that. Attendees will be on mute the whole time, but and will not be able to speak. But if you have any questions, you can enter them into the Ring Central Q&A panel. If questions aren't answered by the end, we will take them offline and answer them later. Also, the slides and the webinar materials will be distributed as well as a recording after the presentation. This is not a comprehensive presentation. There are many important and interesting issues that did not make the cut. So please feel free to reach out after the presentation if there's anything that you were hoping would be covered but wasn't, or wasn't covered in enough detail. That being said, like I said, we will be covering a lot. And there's a good chance we'll run over our allotted time. Please feel free to drop off whenever and just rely on me recording it afterwards. A few things we definitely will not be discussing, or at least not in detail. The moral or ethical arguments for or against cannabis, legalization updates outside the U.S., health insurance, and finally, any opinions. Any opinions expressed during this presentation are solely my own. They do not represent the opinions of AAIS or AICP, and nothing in this presentation should be considered or relied upon as legal advice. So that being said, let's go to one more disclaimer, actually. The AICP antitrust policy. This presentation is intended solely to provide a forum for the expression and exchange of information. It is not intended as a means of restricting competition or affecting the ability of any person to reach independent business judgments. Now, let's get started. Today's presentation is divided into 4 areas. We'll begin with a brief introduction to cannabis, basic terminology and medical applications. Then we'll move on to legalization, both at the state and federal level. We'll talk then about the cannabis economy, statistics, and the structure of the cannabis market. And finally round out with insurance coverage, focusing on current coverage concerns, property and casualty exposures, and cannabis exclusions. So to begin with an introduction to cannabis, some basic terms and concepts. At the risk of telling you something you already know, allow me to go over some important things that I think are that should be addressed. Cannabis, the term cannabis itself, has been adopted by the industry as a means of avoiding the negative connotations associated with words like marijuana, weed, pot, ganja, etc. Cannabis refers to the flowering plants in the Cannabisaceae family. It's an umbrella term that can be used to refer to all 4 species. Sativa is often categorized by stimulating or mind-altering effects. Indica plants are characterized by a more sedative, mellow bodily effect. Ruderalis is kind of the weird cousin. It's a short, stalky plant that grows wild in parts of Europe and Central area. It has very low concentrations of psychoactive components present in the other 2 varieties and has little to no industrial applications. Hemp, on the other hand, is fibrous and contains less than 0.3% of the psychoactive chemical THC. It has a long list of industrial uses as opposed to ruderalis, including paper, biodegradable plastics, paint, textiles, insulation, animal feed, etc. Cannabis contains cannabinoids, a class of chemical compounds that bind to cannabinoid receptors in the brain and body, causing a variety of physiological and psychological effects. There are 3 types generally: endocannabinoids produced naturally by the body, man-made or synthetic cannabinoids, and then plant-based cannabinoids, excuse me. There are over 100 identified species to date of plant-based cannabinoids in cannabis. The ones you've probably heard the most about are tetrahydrocannabinol, or THC, or cannabidiol, CBD. Cannabis also contains something called terpenes, which are essentially a class of fragrant oils produced by some plants and insects. In cannabis, they're responsible for the smell of cannabis, as well as enhancing or adding to altering the effects of cannabinoids in the body. Cannabinoids and terpenes work together in something called the entourage effect, which is a theory based on scientific principles but fueled primarily by conjecture and anecdotal evidence at this point. It says that various compounds in cannabis work best together and should be used together, not separated or extracted in isolated compounds, especially in medical applications. One of the biggest arguments in favor of the entourage effect is that CBD and some terpenes tend to mitigate or cancel out the psychoactive effects or paranoia-inducing effects of THC. So using THC isolates, for example, is believed to be more dangerous than consuming a full-spectrum cannabis product containing CBD and other compounds. The entourage effect is used by the cannabis industry as an argument for why narrow CBD-only cannabis laws are inadequate to address legitimate medical concerns. Another thing you should know is there are many different ways to consume cannabis. You've probably heard of some of them, or maybe all of them. Obviously, there is smoking, vaporizing, eating, absorbing through the mucous membranes, and then applying to the skin. You should be aware that each method has its own advantages and disadvantages and can be distinguished by how the cannabis is absorbed and metabolized, how long the effects last, and how easy it is to accurately dose, and each method's perceived health impacts, smoking versus eating. Smoking and vaping are known for providing a nearly instantaneous or more potent high with a relatively short duration, whereas ingesting cannabis by edibles is best known for its delayed effects and longer overall duration. Finally, what really is the difference between medical and recreational cannabis, or adult use cannabis as it's sometimes referred to? It depends on who you ask and what the cannabis is being used for. A couple of years ago, the answer was that medical cannabis contains higher concentrations of CBD, whereas recreational cannabis has higher levels of THC. But this distinction is becoming much less relevant in recent years with the growing popularity of CBD as a dietary supplement and means of self-medication. So what are the medical applications of cannabis? You've all probably heard a lot in the past 2 or 3 years about how cannabis is this supposed wonder drug with dozens of potential uses. However, there are still significant shortcomings in the knowledge available on the medical use of cannabis in different cases. For nausea and chronic pain management, there is a fairly strong and consistent evidence in favor of medical use. However, for many other indications such as depression, glaucoma, insomnia, and opioid withdrawal, there's far less available and consistent data. You should also know that there are a few prescriptions or medical compounds available commercially. Marinol, Syndrose, and Sesamet are all FDA-approved medications containing a synthetic form of THC isolate used to treat nausea, vomiting, and appetite suppression in cancer and HIV patients. More recently, though, the FDA-approved Epidiolex, it's the first FDA-approved, specifically rescheduled natural cannabinoid-based medicine that utilizes CBD mixture to treat epilepsy. There's a few references down at the bottom of the slide. Again, these slides will be available later. If you want to know more about it, I suggest checking out these links or following up with me. So let's talk about cannabis legalization. Cannabis is still obviously a Schedule I controlled substance. You'll hear that in every webinar you go to on cannabis. It's illegal to produce, possess, and consume under the Federal Controlled Substances Act. But fast forward almost 4 decades to the Obama administration. In a period of 8 years, we begin to see a much more pro-cannabis attitude emerging at the federal level. Highlights include Obama-era Department of Justice memos suggesting a set of federal priorities and a hands-off approach for compliant cannabis industry participants. The first qualified legalization of industrial hemp pilot programs for academic research purposes, an appropriations bill aimed at removing federal funding for the prosecution of compliant medical marijuana programs and participants, known as the Rohrabacher-Blumenauer, formerly Rohrabacher-Farr Amendment, a presidential endorsement for decriminalization, and the highest ever public support, including the first ever majority of Republicans in favor of cannabis legalization. 2018. Well, 2018 began with strong opposition to cannabis by Attorney General Jeff Sessions, who revoked several of the previously mentioned Obama-era policies, including the Price-Cole Memorandum. Many people in the cannabis industry started to panic as the progress of cannabis legalization up until this point seemed to disappear overnight. However, the Attorney General's stiff stance had what I assume to be an unintended consequence, and that it quickly incentivized Democrats and Republicans, state legislators, and governors to condemn the DOJ's new posture and publicly declare their support for cannabis reform. Afterwards, we saw multiple pro-cannabis bills introduced at both state and federal levels. Perhaps most noteworthy, we saw a bipartisan introduction and support for the States Act in the Senate, sponsored by Republican Senator Cory Gardner and Democratic Senator Elizabeth Warren, which would recognize the legitimacy of state medical and recreational legalization programs, essentially replacing the need for the Rohrabacher-Blumenauer Amendment. There is a similar bill also pending in the House. Of course, we also saw California, Canada, and other countries flip the switch on recreational cannabis. I also mentioned the FDA approval and rescheduling of Epidiolex from a Schedule I substance to Schedule V. And then more recently in October, Representative Earl Blumenauer published his blueprint to legalize marijuana in the 116th Congress, encouraging the new Democratic majority in the House of Representatives to own cannabis legalization as a potential political win ahead of the 2020 presidential election. Finally, in mid-November, Republican Senate Majority Leader Mitch McConnell personally guaranteed that hemp will be legalized as part of the 2018 Farm Bill, which is expected to be passed literally any day now, effectively making hemp and by association CBD extracted from hemp legal at the federal level. So when could federal legalization occur and what would it look like? Well, the when is not so straightforward. Educated estimates range from anywhere between 6 months to 5 years. Perhaps some optimistic industry insiders and politicians say 2019 will shape up to be a year of sweeping legalization. Personally, I think more around 18 months is probably pretty accurate. In any event, whenever it occurs, legalization could take many forms. I'm going to go through these semi-quickly and focus on the ones that I think are the most interesting. Full-scale federal legalization is probably unlikely, especially in today's climate. Congress has repeatedly pointed to potential violations of international treaties as a reason to avoid a sweeping legalized initiative at the federal level. And also, it would I don't think there would be support by a lot of the representatives of states that have already legalized cannabis. Another option would be a descheduling or rescheduling of cannabis. You hear a lot about this, rescheduling from 1 to say 2 or 3 or even 5. It would be great for the medical cannabis industry that recognize that cannabis is medically acceptable for certain treatments and would remove barriers to academic and scientific research, but rescheduling would do pretty much nothing to help the recreational market. You also could see more appropriations measures and bills essentially removing funding for prosecution of cannabis offenses. Similar to the Rohrabacher-Blumenauer amendment. That's a possibility, but we're likely to see different steps away from that towards actual bills. Affirmative defenses are another option. They protect from conviction but not arrest, and they're already available in some states, especially also in states where you don't even have a medical ID, but you may be able to benefit from affirmative defense. What's really the most interesting, I think, is state opt-in, opt-out measures, which is pretty much what the States Act is going to be. It's an interesting theory where it means of taking legislation off the federal government's chest and kind of giving it to the states to make their decision, the best of both worlds. It would not legalize nationally, but permit each state to legalize cannabis or continue to prohibit at their option. The approach lobbied by the industry itself is really just targeting the barriers to the cannabis industry and removing those in a systematic way. Obviously, there's criminal barriers that the oppressive lifelong sentences and so forth for certain violations. But really, we're talking about banking restrictions, tax restrictions. You may have heard of 280E, which prohibits cannabis businesses from taking certain business deductions that other businesses can take, and then a whole list of federal hurdles. If you have any more questions about that, feel free to reach out after the presentation. So, not legal at the federal level. So what's been happening? State level legalization. This is what the country pretty much looks like today. Newest updates, obviously, from the 2018 midterm elections include Michigan, which went recreational, Missouri, which went medical, and Utah, which also went medical. Today, we have medical cannabis legal in 34 jurisdictions, which includes 33 states, the District of Columbia, and then 3 territories. Adult use or recreational is legal in 12 jurisdictions, including 10 states, DC, and 1 territory. And then cannabis has been decriminalized in a total of 24 jurisdictions. That's 22 states, DC, and 1 territory. Importantly, this number does not include states like Florida and Texas and others where decriminalization has occurred on a county or municipality level, but not statewide. The other option is the remaining 13 states here are CBD or low THC states. Interestingly, states like Texas would probably not consider itself to fall in this category. It'd probably say it's medical. They passed a medical legalization measure, but because the laws are still so restrictive there's virtually no access to cannabis. So it's still considered by the industry, at least, as being only a CBD or low THC state. Not pictured on here, we have Guam, which went medical in 2014, Puerto Rico, which went medical in 2015, Northern Mariana Islands, which went recreational this year, U.S. Virgin Islands, which decriminalized this year, and then American Samoa, where it's still illegal and has actually some of the harshest penalties in the U.S. By this point, more than 70% of Americans live in jurisdictions with access to cannabis, either medical or recreational. The specifics of legal use of cannabis vary greatly from state to state. The legal specifications are typically broken down into categories, including possession limit, form of consumption allowed, smoking, edibles, liquid forms, whether it can be purchased at a dispensary, whether it can be cultivated at home, and then purchase reciprocity, whether you can go from a state like Arizona with your medical license, go to Pennsylvania and buy from a medical dispensary there. This next map is really just to give you kind of an indication of which states are kind of poised to make some big steps in 2019. Illinois, New Jersey, and New York are really the states to watch, as they're right on the cusp of adult use legalization. Also included, though, Connecticut, Rhode Island, Delaware are similarly kind of watching their neighbors and are working up the steam towards recreational legalization. Not highlighted are North Carolina and North Dakota, both of which are working on decriminalization measures as we speak. So stay tuned is really the message I want to leave you with there. So moving on to the cannabis industry, first, a couple things you should know. Well, there's a lot of stats that I think are included on this slide. I'm not going to go over all of them. I'm going to skim over these statistics in the interest of time. But I want to leave you with two important takeaways. First, estimated sales. Demand and economic impact can vary widely depending on the source, but there's a general consensus that the industry will reach at least $20 billion in sales within the next 4 years. To put that in perspective, that's more than firearms and Netflix combined. Second, the industry is growing on average by about 30% each year. That's 4 times the national average for all U.S. industries and almost twice the growth of other leading industries such as computer system design, e-commerce, and most of the construction and contractor industries. So now let's talk real quick about the cannabis supply chain. I think when we talk about the cannabis industry, we're thinking mostly, at least first, about plant-touching companies. We're talking about seed to sale, the cultivation, the processing, packaging, lab testing and quality control, and then finally the sale to the consumer. And along the way, of course, distribution methods, warehousing, storage, commercial transport, et cetera. But when we talk only about this, we're missing about 2/3 of the industry. Plant-touching companies account for approximately 10 to 15,000 companies in the U.S., but the ancillary market can be another 15 to 20,000 companies. So a total of anywhere between 20 to 35,000 cannabis businesses currently operating in the U.S. The ancillary product industry falls on a spectrum. There's companies that can have up to 80% of their sales coming directly from plant-touching companies, but there are other companies that fall into more consulting route that probably have closer to maybe 20, 15% actually dealing with the cannabis industry. Nevertheless, they're still considered cannabis businesses for the purpose of estimating economic impact. So summary, before we move on to cannabis insurance. First, some of the cannabis is obviously, the biggest hurdle is illegality and enforcement, sure. But one of the biggest concerns to the industry itself is banking, just the ability to grow as a business. Banks are subject to the Bank Secrecy Act, which is regulated by FinCEN, which subjects them to amazingly high fines if they fail to report potential money laundering activity. Interstate commerce is an interesting issue. It basically, the problem is like where you have states that have surpluses, such as Washington or Oregon, but you're running out of cannabis in states like Nevada, they can't just go ahead and transport that surplus to Nevada, which kind of puts a barrier on the growth of the industry as well. Foreign competition is a big concern in the industry now, especially with our neighbors to the north and not very long the south as well, Mexico, legalizing cannabis. Europe, Greece, and in Asia we have South Korea. These economies are now fostering the growth of large cannabis businesses, or potentially large cannabis businesses, who, if America continues to wait, will be able to move in and potentially take up a large part of the market space or take over cannabis businesses in the U.S. Very real concern, I think, from an industry perspective. There's also restrictions on vertical and horizontal integration in certain states, which also kind of prevents the growth of these cannabis businesses into businesses that can compete on the international stage. Public opinion, education, and expectations present significant hurdles as well. The public opinion obviously being ethical and moral objections, education being an issue for people who are just coming to the cannabis industry now, or are revisiting it after years of not partaking in cannabis. Talking about the older hippies, right, who are coming back and now it's legal and I have joint pain. Let me take an edible for it, but they've never taken a commercial grade edible before, or an edible similar to what's available in today's market, and so it leads to just negative experiences. One of the only constants in the cannabis industry is change. I know that sounds kind of cliche, but it's accurate. It seems like every month, California and other states are revising or issuing new emergency regulations to replace this, that, and the other thing. And it's difficult from an industry perspective to keep up with that, from the business perspective to stay compliant when you have stuff changing so fast and so often. The cannabis industry is also becoming an easy target for crime, enforcement, and litigation. Crime being pretty obvious, enforcement being regulators who are just getting comfortable with the cannabis regulations and are now taking up the task of weeding out the industry, so to speak. Litigation, multifaceted. We're talking about, of course, consumer actions. We're talking about criminal prosecutions, but we're also talking about infighting between cannabis industries, between the cannabis businesses. We can talk about a little bit more about that in a moment, and what kind of risk that poses for the insurance industry. Scientific research, there are significant barriers to scientific research in the cannabis industry that lead to studies that are never completed, studies that are skewed by poor quality cannabis that is tested, and also encourages the study of individual cannabis chemicals as opposed to further research on the entourage effect and how the compounds interact with each other. And then, of course, there is a lack of, according to many industry participants, a lack of quality insurance solutions. Let's talk a little bit about those, about cannabis insurance. So some of the insurance challenges and considerations. First, cannabis is insurable, and cannabis insurance policies are enforceable. Second, cannabis risks are far from uniform. The market is home to all kinds of innovative products and services and exposures that can vary dramatically depending on what section of the cannabis supply chain and the insured occupies or serves. Third, cannabis is absolutely a specialty niche market that has been served to date primarily by the surplus lines industry. They have done an excellent job of responding to the demand of cannabis insurance. However, many policyholders and regulators are growing increasingly wary of the surplus lines companies and their freedom to openly experiment with coverage limitations and exclusions. This has led to a growing call for admitted carriers to enter the market with standardized products and programs. California Commissioner has kind of led a recent campaign to encourage admitted carrier growth. While some carriers have entered the market, they're not bragging about it. In fact, many are keeping their involvement quiet for fear of federal enforcement and reputational damages. Fourth, there is some debate as to whether it's acceptable to utilize existing commercial and personal insurance forms with cannabis-specific endorsements, or better to utilize more targeted, specialized cannabis insurance programs built specifically for cannabis exposures. I don't think there is a real answer here, but I will say I have seen more problems with insurers trying to squeeze cannabis exposures into existing insurance frameworks than they have with newly developed specialty insurance projects. Perhaps that is because the specialty products haven't been tested yet, but it could also be because existing personal and commercial coverage frameworks just don't properly contemplate many of the exposures presented by the cannabis market, leaving courts open to interpret them as they see fit. Fifth, there is also some disagreement in the industry over the necessity and the adequacy of existing cannabis exclusions. I've spoken with carriers that find existing exclusions are not broad enough. They are terrified of hidden exposures or unanticipated policyholder activities. While on the other hand, policyholders and regulators tend to find them, they can be overly broad and create illusory coverage. Finally, there is still much more we don't know about how a lot of typical coverage issues will play out in the cannabis insurance market. Additional insured endorsements is one example. Valuation of cannabis property is also a sticky subject. The bottom line is that the insurance market for cannabis is underdeveloped in a lot of ways, making it tricky for carriers to accurately evaluate the pros and cons of entering the space. Let's talk real briefly about the legal basis for enforcing cannabis coverage. You can't really talk about cannabis insurance without starting with Tracy v. USAA, in which a plaintiff filed a claim under a homeowner's policy for the theft of 12 marijuana plants. The court found that plaintiff did have an insurable interest in her cannabis plants and that the policy did cover the loss, but that the policy was not legally enforceable as a result of the federal illegality of cannabis. Well, fast forward about 4 years and you have Green Earth Wellness, where the question was whether a CGL policy covered loss of marijuana stock. The court, building on Tracy's conclusion of insurability, found that coverage was available despite a contraband exclusion and the contention that cannabis coverage is against public policy. The court said that the insured cannabis business had a reasonable expectation of coverage for while being in a cannabis legalized state. The insurer knew what it was insuring, again, insuring a cannabis business. And 3, even though federal law prohibits cannabis possession and activities, the government had been broadcasting conflicting signals regarding cannabis regulation and enforcement since 2009. Green Earth has been cited as a turning point, I think, for cannabis contracts in general, but specifically insurance coverage. Along those same lines, you have Mann v. Gullickson, which is a Northern District of California case from 2016, which basically stands to the proposition that if a contract concerns illegal objects, it might still be enforceable by parsing out portions of it in a way that does not require illegal conduct. The court is not barred from according, contractual relief just because the contract covers cannabis. This principle, enforcing contract provisions that do not directly violate federal law, has been cited by multiple courts since in support of honoring, whenever possible, the terms agreed to by the parties. For example, in a more recent Nevada case involving promissory notes against the cannabis cultivation business, the court was able to parse out enforceable terms, such as paying off debtors and purchasing real estate, from terms that would be considered direct violations of the Controlled Substance Act, such as investing in the cannabis business or enforcing the right of first refusal to purchase the business. Another the last cited case here is KVG Properties v. Westfield, which is a Michigan landlord-tenant case where tenants were caught growing cannabis on the premises and evicted. The landlord discovered hundreds of thousands of dollars in damages to the premises and sought coverage under its standard commercial property policy. The court could have easily sided with the policyholder if not for the fact that he admitted that the tenants were operating the facility illegally under Michigan law. I think that KVG is notable in that it demonstrates, 1, that courts are becoming well-versed in cannabis issues, regulations, and contracts. And 2, it reassures the insurance industry that courts are not blindly finding cannabis coverage in medical and recreational use jurisdictions. But 3, I think, most importantly, it highlights the importance of cannabis-specific policy exclusions to preclude hidden cannabis exposures, especially in policies issued to insureds in medical and recreational use jurisdictions. Let's move on to talk about some property and casualty exposures from an underwriter's perspective, I think. We'll begin with homeowners. There are some first-party and third-party claims to talk about. First-party, we're talking primarily about home growing operations and exposures to personal property created thereby. We're also talking simply about claims for damage to cannabis property itself, including the cannabis products you purchase and also paraphernalia and equipment. But more importantly, I think we're talking about third-party claims and how those impact the insurance industry by creating exposures for using cannabis with invitees, creating dangerous conditions in your home growing operations, and then nuisance claims, of course, and how those play out with your neighbors. But one topic that's kind of near and dear to my heart is consumption by minors. It's not hard to imagine some sort of hypothetical where the homeowner's children or neighbors' children come over and discover a shoebox with no lock on it, and inside are cannabis brownies or gummies, and the children either consume those products or they take them to school and expose others to it. There's recently a case just like that. And then whether or not those kind of claims that arise out of that would be covered under a homeowner's policy. Another area of interest is personal and commercial auto claims. We're talking primarily about impaired driving. It's a very hot topic right now. There are about 4 companies currently working hard on developing reliable field testing techniques. But a majority of police forces are currently opting for specialized training of officers to recognize and address the impairment in the field. Another topic under transportation is the gig economy and cannabis delivery in states like Nevada, where cannabis can be ordered and delivered. The question is whether cannabis delivery would fall within the scope of existing TNC endorsements. Finally, the commercial transportation of cannabis from one site to another and the transportation of cash revenue creates serious exposures for theft and other crime. Commercial property, we're concerned obviously about indoor growing operations and cannabis storage solutions. We're also concerned about spoilage and contamination claims. But some lesser recognized, I think, issues are equipment breakdown, probably underestimated issue in the industry, dealing with very expensive, sometimes highly customized machines and equipment presenting valuation and replacement problems. Finally, RICO litigation is a hot topic for some cannabis businesses. I won't go into a lot of detail here, but suffice it to say that industry opponents have discovered in recent years that they can effectively drive some cannabis operations out of business simply by bringing a trumped up nuisance claim as a RICO action and then naming all the companies that do business with that operation. And going down that defendant's list and kind of convincing them we'll release you from this costly litigation if you agree not to do business with this operation. Some additional P&C considerations, of course, revolve around liability. One of the more obvious ones, or ones that has been tested, is labels and packaging. This falls into two camps primarily. First, you have child protected packaging and compliant labeling that accurately designates the contents as containing cannabis, whether or not you comply with those kind of requirements under state law. But second, and perhaps more interesting, you have issues. An issue that was fairly pervasive a few years ago, but has since been cleaned up mostly, where many edibles manufacturers in states like Oregon, Washington, and California were creating parody candy brands like Pot Rocks and Reefer's Pieces and Charleston Chiba. Aside from some of the obvious IP issues there was a real concern that this was painting cannabis in a child-friendly light and then opening the door to sales and advertising to minors and claims arising from that. Speaking of intellectual property, though, some attorneys I've spoken to who have closely been monitoring the industry happen to be IP lawyers who have said that they have dozens of complaints already drafted and ready to file as soon as federal legalization takes shape. This signals a potential wave, I think, of intensive litigation, costly litigation, which can sometimes stretch for years and will likely kill the industry and put many companies out of business. Bud tenders and the unauthorized practice of medicine or pharmacy is another interesting issue. I think many dispensaries nowadays are adopting a medical-like stance in an effort to legitimize the industry and their products, but it could backfire spectacularly with the right mixture of angry consumers and inappropriate advice. The primary concern is that dispensary bud tenders are holding themselves out as experts. Sometimes they possess certifications and so forth, then the consumers are being told how and what to consume. If there's some sort of overconsumption or adverse reaction that happens after they leave the store with their product, the bud tender and the dispensary could be in a lot of hot water, facing regulatory fines, civil lawsuits, and reputational damage, both to the company and the industry as a whole. I'm not going to say much about paraphernalia hazards. I think we're very familiar with foreign-made vaporizers and batteries, which can be cheaply made and then often have tendencies to explode, and the lawsuits that arise out of that. Regulatory violations and consumer actions, though, I can't take credit for this one. The concern was first brought to my attention by Ian Stewart from the law firm of Wilson Elser. Essentially, Ian notes that the plaintiff's bar is keeping a close eye on the cannabis industry, and in particular, the ability of public-facing companies to keep up with and compliant with literally thousands of regulations at a time. Plaintiff's attorneys are likely to find small things, just anything, whether it be a mislabeled bottle or a mildly contaminated product, and then bring a consumer action under a state or federal consumer protection statute, which notoriously have high standard and even higher fines that can easily put smaller companies out of business and just cost hundreds of thousands of dollars in defense fees alone. Directors and officers, just a few takeaways. D&O coverage is a hot commodity in high demand, but often reported as the hardest to obtain. I think there's a lot of changes that need to happen at this level, which we just haven't seen those really yet. The surplus lines industry has been trying to serve this space, and they've done so, but I don't think policyholders are really happy with what they've gotten. A couple of specialty areas: crime coverage, obvious, crime, theft, burglary risks for a mostly cash-based industry. Cybersecurity, a not fully recognized issue, I think. Many dispensaries process personal data. You go to a dispensary in Nevada, LA, for example, the first thing they do is check your license, and sometimes they'll scan it or take a photocopy of it or write down your information, then they store it, which makes it ripe for being targeted by cyber criminals. Then the industry can be held ransom, or they can just flat out do a data drop, and then you're dealing with the fallout from that. Farm and crop coverage. We're talking, this is actually a very nuanced area, and one where I think especially standardized available products just don't fit. You need specialized cannabis crop products to cover the various phases of the crop, clones, mother plants, etc. Catastrophic losses, such as in the wildfires in California, where millions upon millions of dollars worth of crops can be lost literally overnight. And then dealing with competing supply models. There's a commodity model where it's just, produce as much as you can, as quickly as you can to get it to market, versus more of a craft, slow down model, which might have different underwriting impacts. Finally, the next trend, I think, the next biggest trend for the cannabis industry, especially in states like Colorado and California, is open consumption and special events. We're talking about cannabis cafes, of course, on one hand, where people can purchase cannabis and then consume it, or just bring their own cannabis and consume it, or special events. We're talking, Coachella or other, concerts and conferences and so forth, where the participants would prefer to be able to consume and purchase, trade cannabis. And how do you cover that? How do you deal with the exposures? How do you deal with an event that intends to mix cannabis and alcohol, and so forth? So a lot to be talked about there, probably more so than we can talk about in this presentation. So if you have any questions about that, feel free to reach out. Finally, insurance options are increasing for P&C coverage exposures in the admitted space as well. AAIS recently came out with their cannabis business owners policy, or CannaBOP program, which is a package policy like any other BOP containing property and liability coverage. It's currently approved in California, with filings anticipated in Colorado, Nevada, Massachusetts, and New Jersey. Some of the key features include pretty clear and straightforward product liability. It's designed to cover small and mid-sized cannabis businesses, so not the larger businesses such as MedMen that operate in multiple states. This policy has territorial limitations, so only covers the state in which it's been issued, and make sure there's no coverage for cannabis crossing over federal lands. There's compliance equals coverage, essentially. If you follow the state and local regulations, you have a better chance of coverage, or if you don't follow them, there's absolutely no coverage. Tracking requirements are built in, and then of course there's specific exclusions for extra exposures such as cannabis delivery. We have a short amount of time left, so I'm going to jump right into workers' compensation. There's a state split on whether or not payments are covered under workers' compensation, payments for cannabis items, cannabis prescriptions, and so forth in medical states. Most states also preclude or restrict employer liability for injuries caused for employees who are under the influence. But there's extra levels of proof involved with that. You have to prove that they were intoxicated at the time and it was proximately caused by that intoxication. One of the more interesting topics in this arena, and probably the most recently debated, is drug-free policies, screening, and the right to terminate. For a couple of years, we're all operating on the impression that there's just no general right to use marijuana, and that employers were permitted to maintain drug-free policies, and that employees can then be terminated for violating those policies, even if they're used outside of the office. Well, recently we saw a case called Nossinger developed in Connecticut. It basically asked the question, well, but what if the state legalizing cannabis also prohibits discrimination based on medical use? The court worked through a couple of ideas that essentially reached the point that said that the Controlled Substance Act does not itself prohibit employment of cannabis users, and the Americans with Disability Act does not authorize employers to take adverse employment action based on drug use outside the workplace. Therefore, if a state law prohibits discrimination on the basis of medical cannabis use, then it controls, and an employer can be liable for terminating based on that use. I keep a close eye on that. If you're interested for an appeal, I think the employer has signified that they will be appealing that up to the appellate court level. Finally, I just want to briefly cover cannabis exclusions. Here at AAIS, we follow kind of what we have lovingly termed the vape approach. We look for versatility, capable of multiple applications, adaptable to the ever-changing, ever-expanding industry. That's so versatile. Acceptable, has to be reasonable in scope and application, both to regulators and insureds. The exclusion definitely has to be precise in word choice and triggers. So pay special attention to how cannabis is defined, how and to what extent ingestion, intoxication, and acts under the influence are excluded. And then, of course, has to be explicit as to the exclusionary nature and the scope of what is being excluded, and when it applies and how. We have seen, there's a lot of exclusions that are in the standardized policies, and courts have been just kind of systematically brushing them aside, talking about contraband, illegal acts, impairment, and vaporizers and stuff, unless it's specifically tailored to the cannabis industry and broad enough to cover state legalization measures. The exclusion stands a much smaller chance of succeeding when it comes to being tested in court. There are some broad endorsements available out in the market currently. AAIS, for example, has come up with two. The CL 810 was in response to Oregon, which requested that the P&C market operating in Oregon add some clarity to the market with, saying specifically to what extent cannabis is covered, and how much. Well, we then took that endorsement and we made it into a multi-state endorsement, CL 0811, which is now we're filing it across the United States. We've completed filing in all the recreational states and now moving on to medical use states. ISO also has some endorsements. The ones I've been able to find are Oregon-centric, but I believe that they do also have some endorsements or excluding endorsements that apply in other states or even nationwide. If you have any questions about that, feel free to reach out after the presentation. I think that it's a very, very interesting topic and one that's difficult to anticipate because a lot of these exclusions, cannabis-specific exclusions, just haven't been tested yet. So that about wraps up the presentation. There are some additional resources that I added on the slide deck. Please feel free to check these out. I check back with them on a monthly basis just to make sure I'm not missing anything in my news feed. They're very informative. I highly recommend MJBiz and the NCSL website, NAMIC as well. So with that, I'll say, please feel free to reach out to me after the presentation. But if you have any questions now, I'll be happy to take a look. Looks like we've had a couple roll in. Let's see. First question is, okay, what is the difference between hemp CBD and CBD extracted from other species of cannabis? Great question. I'd say almost none. CBD is CBD as far as I understand. It has the same chemical structure and components, no matter where it comes from. Where we really start to see differences in regards to what other compounds might be included in the CBD product and in what concentrations, most notably THC in these recreational states that offer full spectrum products. Okay, next question. You mentioned RICO litigation. Can you go into more detail? Yes. RICO is a federal statute that provides for a civil cause of action for acts performed as part of an ongoing criminal operation or organization. RICO claims started showing up, I think, a couple of years ago as a creative way of making a federal case out of an ordinary civil nuisance claim and essentially forcing or encouraging support businesses to cut ties with certain cannabis businesses. I think I already mentioned that, but the problem recently is that plaintiffs are having a really difficult time proving that the mere existence of a cannabis enterprise has caused any compensable damages. There's a recent case recently in Colorado, so you can check that out, where basically it's the first time really that the court kind of struck aside a RICO claim. I think it was actually brought by I can't remember the name of the organization now, but yeah, an excellent and interesting topic that I think we will see kind of start to fade very soon. Next question. Okay, do states require cannabis companies to carry insurance, and if so, which ones, how much? Good question again. Some do, some don't. I'll see if I can recall correctly. Some still allow cannabis businesses to, kind of do whatever they need to do, including self-insuring. But I believe California and Washington do have requirements. California requires a general liability coverage in the amount of $1 million per occurrence, and I believe $2 million in the general aggregate. Washington, on the other hand, requires only $1 million aggregate, but it does also interestingly require that the state and its employees be named as additional insurers to that policy. I think I have time for one more question. Let's see. Okay, here's one actually I received earlier this week. Looks like someone repeated it, or maybe someone new asked it. Should insurance companies be concerned about accepting premium payments from cannabis companies? Excellent question. I think the short answer is no. Banking institutions are concerned for good reason. As I mentioned earlier, they're subject to the Bank Secrecy Act and have reporting requirements for anything that looks suspiciously like money laundering, or even just could potentially look to FinCEN like money laundering. But it's not the money that's the problem, it's the intent behind the money. If there's a possibility, like I said, that the money laundering scheme, then yes. There's next to nil concern, I think, for insurers because it's nearly impossible to effectively launder money through the payment of premiums. Insurance policies are not banking accounts, where money goes in and they can be thrown freely. So if anyone has more questions about that, I first recommend watching Ozark on Netflix and then contact me afterwards. Let's see, one question here. Michigan did not have a star indicating decriminalization. Is that accurate? Right. I think Michigan actually, was it yesterday or this morning, actually announced that they had passed a decriminalization matter. So yeah, that's a good catch. I did not update that slide fast enough. Let's see. Here's a question about AAIS. Is AAIS working on the development of other cannabis programs besides Cannabop? Yes and no. I think AAIS is currently exploring options for homeowners, commercial auto, inland marine, and even farm and ag. However, the production of standardized programs in these areas is not expected to be completed this year. Instead, and we've kind of recently been reserving time and resources to develop customized products for interested carriers and MGAs. And I would invite anyone who may be interested in such products to reach out to us. We also take our role as an advisory organization pretty seriously. So we're not just a form mill. We are also focusing on the development of educational resources such as this, webinars, conferences, presentations, articles, and reference documents, etc. I believe that's all the time we have. So thank you again very much for joining me. Please feel free to reach out to me. If there's any questions I did not get around to answering, I will personally make time tomorrow and next week to do so. Yeah, thanks again, and enjoy the rest of your day.